those terms of reference. But in the course of doing so, one gets a better idea of the organization, the organogram, what people do, what kind of work is done, etc., which helps one then to get into the others about the organizational structure and so forth. Now, all of those that were identified as being in that category of having resigned or alleged to have, or alleged that they had been coerced to resign or leave for other reasons, were called, except for one. There was one woman who told a very strong and sad story. I said, will you go and give evidence? She said, I don't want to. I don't want to be in the public eye. I've had enough. I'm in pain. I don't want to do it. Well, I could have compelled her to come as well, but I wasn't going to compel anyone of that kind to come and give evidence. So the others that were called were those that fell into that category who had been defined as falling into those terms of reference. That's why those were called. Now, I've also found in life that one can build conspiracies, and the fewer facts you have, the more easy it is to build conspiracies. The more facts you have, the more difficult it is. It trammels you into what actually happened. But to build conspiracies requires few facts. And I suggest to you that when suggesting that there was some conspiracy about the witnesses were called, you might not have been aware of the facts that I've outlined to you, which might have influenced what you said, and you might have not said the same thing. But I just leave that with you as well. Now, where are we? I quite agree with you. Fairness is a cornerstone. I think my life on the bench, I've never been told to be unfair. You can tell me if I have. You know me very well.
That I know.
In fact, you were my junior when I was an advocate.
I know.
Yes.
And you are very fair.
And in fact, you sat with me as an assessor on the labour courts. Do you remember that? We were all a lot younger than Mr.
We were.
But time goes on, but you'll remember those. Now, I don't think you ever said I was unfair when we heard cases in the labour court. I never heard you say when we ran cases and you were my junior, look, you're acting unfairly. But let me tell you this, we can all do it. We get a sense of what we think is fair, which may not be shared by others. So I appreciate that fact, that others may see it differently. But when you look at fairness, as you know from all the cases, you've got to look at the particular situation you're faced with, and you say, in that situation, what would the fair thing be to be? To me, it was perfectly fair to call those witnesses as a bunch, hear what all of them said, and then allow your client, if he wanted to look at their evidence, examine it, and then decide where to. So that was my idea. That your client would have an opportunity to deal with. We've got until November. There was never any doubt in my mind. But let me add as well, I won't compel your client to give evidence. It's his choice. He must be informed, he will make a choice, and if he wants to, he will give evidence. And we can arrange that, as I've arranged with Mr.
Makwakwa.
Yeah, Makwakwa, who is coming to see me next week to discuss what is the best way for him to do so. So that really deals with how it came about that these witnesses were called. Now, paragraph 26. Part of the unfairness is the failure to invite the Commission. I didn't invite anyone sitting in this room. I told them that it is a public hearing, and by implication, a public hearing means anyone can attend. And your client is also part of the public, and he was free to attend. He chose not to attend, despite being told that, and he said, we've got other business. His attorney said, we've got other business we need to attend to, but we'll come on Friday. Eliciting evidence adverse to Commissioner Moyane's rights without giving him an opportunity to rebut the same. He will have the opportunity to rebut the same, but it is 3 days into the hearings, and we have until March, till November. Choice of witnesses, I've dealt with that. Facing 2 inquiries by the same person. There are not 2 inquiries by the same person. Advocate Bam is doing his work, and he will be left to do his work, and I'm doing this work. There are not 2 inquiries by the same person. Now, you've handed to me you've told me a lot of facts, And I hope, and I invite you, Mr. Mpofu, to bring evidence in support of those facts. You heard me this morning say to the media, and I've said it a number of times, anybody who has any evidence that is relevant to this inquiry or any submissions they make, please bring it forward. I appeal to them so it can come forward as soon as possible so we can get our work done without ending up trying to finish it, put it in at the last moment in November. Now, so all of this, I mean, these facts, press can repeat them if they want to. That's not my business. But as far as you've given me a memory stick, I don't want this memory stick. Give it to me if and when your client gives evidence. For the rest, give it to the press as far as I'm concerned. Let them publish the whole lot. I'm indifferent to that. I will do my work and they will do their work. So here is your memory stick. You can give it to the press. Now, you say as part of the unfairness, it has been established that these characters refused to testify before the ongoing KPMG inquiry chaired by Advocate Nsebeza on the grounds that they are still facing a criminal prosecution. They have, however, been keen to testify before this particular inquiry for obvious reasons. I'm not sure how obvious they are. Perhaps they were willing to do so because it's the first time in 4 years, according to some of them, that they've had a chance to have their say. That might be the reason. But don't forget, Advocate Nsebeza has no powers of compulsion. All of these witnesses were told that if necessary, I will compel them to give evidence. They didn't have a free choice. They had a choice to do so under the threat that if I thought it was relevant, they would be compelled to come here. You say they were keen to Russia to be dealt with as sweetheart evidence. Well, don't talk to Advocate Steinberg. It didn't look like very sweetheart to me. And you say in paragraph 35, the witness list makes very interesting and curious reading. It suggests that there was an earlier evidence gathering stage to determine the alleged relevance of the evidence, and also some witness preparation. Let me tell you as far as witness preparation is concerned, I specifically instructed counsel, you do not prepare the witness. But in every commission of inquiry, one makes inquiry, one interviews the witnesses to see if they're going to contribute anything. You don't call witnesses not knowing what they're going to say. Otherwise, I mean, you spend thousands there are 14,000 people in this organization. Do you think I'm going to call 14,000 people and say, do you know anything about any of these things? We interviewed witnesses, selected by reference to the term of reference, and they were interviewed to see if what they said would be relevant in the sense that, that they were going to tell us anything about what we were going to find. So it does make interesting reading the witness list. It is interesting because those are the people that fell within the terms of reference. The hostility of the principal witness and architect of this process, Mr. Gordon, towards Commissioner Moyane, is so well known that the Commission would be hard-pressed to deny knowledge thereof. Quite frankly, I don't know about this relation. I know nothing about handshaking or not handshaking. I don't read the newspapers a lot. I have read from time to time that Mr. Gordon and Mr. Moyane are in some conflict. I don't read it. I'm not interested. You know what I do, Mr. Mpofu? I grow vegetables.
Good luck to you.
I assure you it requires a lot of luck, very difficult. Yeah. But that's what I do in my, that's my day job. This is an extra job. My day job is I grow vegetables, I read books and so forth. I don't read the papers. My wife brings them home, and I said, don't bring them home. I don't want to hear about the troubles in this country. I want to grow my vegetables. The choice of witnesses also exhibits that the Commission has prejudged the issues before it and is merely going through the motions to reach a predetermined outcome. This is patently unlawful. Of course it would be unlawful if the matter has been prejudged. You've seen a judgment written by me, because I'm sure you read all the judgments. It says the following: to instruct people who have to hear and decide issues. They must keep an open mind. But it also says an open mind is not the same as a blank mind. One hears the evidence, it makes an impression on you in one way or the other. At that time, But you don't make, you say, well, that looks impressive or doesn't, etc., as you know when you sat with me in the Labour Court. But what you also do is you say, but hang on, let me wait. Let's hear the other side. Let's hear if there is another side, by the way. And if there is another side, one listens to that, it makes an impression upon you, and at the end of the day, you sit down, you take the two, you look at what was said, you ignore what the media has said about it, which I don't read anyway. You ignore that, you look at the facts that have been given, the evidence that has been given, and you weigh it up against one another and say, which one do I believe? Now, that is what I've been doing for 20 years, and I'm going to do the same here. Now, now let's go to the two separate tribunals. Look, I didn't appoint any of these tribunals. The President did. I have no idea why he appointed the two. The President office phoned and said, will you constitute this commission of inquiry? I said, send me the terms of reference. I looked at them and said, yes, I will. I did because I thought I'll leave my gardening and get back into public life and see if I can do something that is useful. I don't know why there are two separate tribunals, and I'm not interested. I have read, I think, in the newspaper that affidavits have been filed in the other matter. I have no idea even when they're going to be answered or whether there's a date or whatever. I will get on with the work because a proclamation has said, and I've accepted that appointment, you must do this work and do it by November. And I will do that, and if Advocate Baum's matter has got nothing to do with me. You say in 40.2, it is a trite principle of the common law rules of fairness and justice that a person cannot be tried twice for the same offence. There is no offence alleged here. We are not trying anyone for any offence. Any decision we made, unlike the decisions I made for 20 years, which had consequences. People went to jail, they had to pay money or whatever. There is no decision being made by me with the assistance of my assistants. We are finding facts to report to the President. What he does with them is his business and not mine. There is no finding of fact. I might get the facts wrong, and the President might act upon them. Well, if I get them wrong and he acts upon them, the President can blame me, but I'm not, there's no offence committed here. I've said a number of times to the people who have been here, this is not a trial. This is not an adversary process. This is an inquiry. An inquiry means you inquire into what the facts are. I am keen to do so because I've been told to do so and because I think it is in the interest of the country that facts be brought to light. You say the overlaps between the two inquiries are self-evident. It is indeed so, this is 41, that in addition, one of the two reasons originally cited by the President for his alleged loss of confidence, namely the VAT refunds, miraculously did not appear in the charge sheet. Well, what is the problem with the VAT refunds, by the way, is this. As I understand it, we haven't inquired too much. Businesses have been complaining to the Ombudsman for a long time. They say our VAT refunds are not being paid. Why that is so is one of the questions that we ask. Why are these VAT refunds not being paid? The little I've been told about it thus far is they say, look, it's important that these VAT refunds be paid because it is money back into the economy which generates more money, which attracts more tax and so forth. That is what they're concerned with. They're concerned that business is complaining. Of course it wouldn't be in the chart sheet. I wouldn't imagine it would, but I mean, I didn't draw the chart sheet. They can put in it what they like. I've dealt in 42 with the kangaroo court. As you say in 43, and the mistake that is made there, you give an assumption. Assume this commission finds Mr. Moyane innocent or guilty. We're not here to find whether he's innocent or guilty. We're here to find the facts. And just on that point, you say this is known as the Moyane inquiry. Well, I haven't heard it referred to that, but maybe the press are referring to that. As far as I'm concerned, and I've asked people, this is to be called the SARS inquiry. They say to me, look, we can't dictate to the press, and I say, of course you can't. But as far as I'm concerned, I would prefer it to be known as the SARS inquiry. If people are calling it the Moyane inquiry, then they are quite wrong. This is not an inquiry into Mr. Moyane. It coincides with the time that he's the commissioner, obviously. Now, in that sense, Mr. Moyane, he was the commissioner during that period, and some of the things that we are hearing about and might find, of course they were done under his watch, and they will come back to home for him. That is the nature of being a commissioner, someone at the top. Things that happen in your organization come back to you because you are the boss. So far as it is a Moyane inquiry, it is not a Moyane inquiry. I acknowledge freely that a lot of the evidence will refer to Mr. Moyane as it has already. Now, bias, well, I think I've dealt with that. Now let me turn to Professor Katz. I asked Professor Katz when I got the first letter from Mr. Babuza. I phoned Mr. Katz and I said, Professor Katz, will you do a favour for me? It is alleged that you are friendly with the President and his lawyer and so forth. Will you just write for me a letter? Don't comment on it. Write for me the facts of your relationship with Mr. Ramaphosa. Well, he wrote that for me. I'll give you a copy. This is what he says are the facts. Let me read it to you. Dear Judge Nugent, as requested by you, the information you have sought is set out hereunder. On 11 and 12 August 2014, ENS Africa represented Mr. Cyril Ramaphosa, who was then Deputy President, at the Farlam Commission of Inquiry investigating the events at Marikana. The ENS team consisted of Michael Katz, Sue Hayes, Head of Litigation, and Kabwela Chisaka, an Associate. ENS briefed Advocate David Untholder. After the report handed down by Judge Farlam, which did not find then Deputy President Ramaphosa guilty, legal proceedings were instituted against a number of parties, including then Deputy President Ramaphosa. The proceedings commenced with a summons. The litigation department of ENS, conducted by one of our partners, Doug Molepo, is representing President Ramaphosa. Salient features of those proceedings are set out in the schedule prepared by Mr. Lopper. That is Professor Katz's account of his relationship with Mr. Ramaphosa. I don't know if it's correct or not. Maybe that he visits his home for all I know. You've given no evidence that he visits his home. You just state it as a fact. I don't know if it's true or not, nor would I think to you. If you had known it was correct, you would have said so. And said why. So I'm not sure that you can be said to be his personal lawyer. And you go on to say the President could have done things another way. Well, the President must do what presidents do. He's chosen this way, and this is the way we will continue until such time as the President says, I don't want you to do it anymore. Now, the principle underlying this particular objection that's is nemo judex in causa sua. No one should be a judge in his or her own cause. Mr. Katz does not have a cause here. Professor Katz, to me, I'm very glad he was appointed, by the way. Professor Katz is deeply involved, probably more than anyone else in this country, although Judge Dennis Davis will probably deny it, in tax administration and tax governance. In the early 90s, Professor Katz chaired the Katz Commission of Inquiry. It went on for a long time. There were many recommendations made. If you'd read the report, I've read part of it. It's too complex for me in parts. But if you read the report, you'll see that it is a major study on tax governance in a tax revenue office. Now, if you're asked to inquire into, as we are, and make recommendations on tax governance structures, who would one go to get the best advice? I would go to Professor Katz. He is the expert in the field. But let me tell you, you may think differently, and maybe he shouldn't have been appointed, etc., but let me tell you my difficulty. I did not appoint Professor Katz. The President did. There is a proclamation that says that Professor Katz is an assistant to this commission. And if the President says that in a proclamation, then Professor Katz is an assistant. I can't tell Mr. Katz to go. I must say at times I wouldn't mind if I could. But I can't tell him to go. This should be addressed to the President. Say to the President, please take Mr. Katz out of that, Professor Katz out of that commission, but I regret to say I can't even think of doing anything. I don't have the power to do so. Now, I've spoken on a lot of things. Just to put some of these things in proper context and see why things have been done, and to add some facts. As I said at the beginning, conspiracies become easier and easier. I've seen it in the courts over and over. Conspiracies are easier and easier to construct the fewer facts you have. They become more difficult once you have more facts and more facts. They become more difficult. I would like you to just, these are other facts that I'm suggesting. And now, if you don't mind, we're going to adjourn for a short while so I can have a cup of tea. Is it okay?
Yes, no, you can have a cup of tea, but will I have an
what do you want to
opportunity
reply?
to respond?
No. What do you want to respond to?
No, of course. You've made all sorts of...
I'm not having arguments.
No, no, it's not argument, but I simply want to make submissions
if you want,
on behalf of the
I don't
client.
want submissions. If you want to add any facts, then add the facts.
Yes, I would like to.
If you want to
and
add
I'd like to address some of the misstatements and misunderstandings of what I was proposing here.
No,
all this is very interesting, Judge Nugent, but I've raised only two issues really, which is it fair or is it not fair to have Mr. Moyane facing two inquiries? You say it's got nothing to do with you. I will demonstrate that it has a lot to do with you. The second one is whether Professor Katz, even with this letter, is somebody who should sit here, and again you say that you don't have the power. I'll show you that you do have the power.
Okay, that's fine. On those two issues, I'll certainly hear it, because I'm not making any rulings. I'm simply adding other facts.
No, I accept.
I haven't made any ruling. I've made no decision. I have an open mind, but not a blank mind.
Yes, no, I know that, but I want to address some of the issues you've raised. That's all I'm saying.
If you would like to address those two issues, and we can go back.
No, not just those two issues.
You've
raised about 20 issues.
No,
I'd like to address some of them.
Okay, Mr.
Yeah, because, you know,
Mr. Mpofu,
other people might
Mr. Mpofu.
Yes.
Let me just ask you, just give me a moment to say something. You can address those two issues when we've had a cup of tea. You're welcome to. I've told you that as far as those two issues are concerned, my problem is this, and you will address that in particular. I did not appoint Professor Katz.
Yeah.
If there is a proclamation that says Professor Katz must assist us in this, tell me on what basis I can say, no, you don't.
But that's what I'm proposing to tell you.
I understand. Let's just say get clarity as I have my cup of tea.
I'll give you the clarity.
And the second thing that you are concerned about is the disciplinary inquiry. That was established under a separate proclamation. Am I in a position to say I will not continue with what I've been instructed to do under this proclamation because there is no one? What power do I have to do that? I've been appointed. I must do the job that is had. So they're the same point in both cases.
I've heard you, Judge Nugent. The question is whether I must respond now or after your cup of tea.
I'd like a cup of tea first.
Thank you.